Hello everyone. In this series of presentations on constitutional law, an attempt would be made to explain the salient features of the Constitution, the preamble, the fundamental rights, directive principles of state policy, and fundamental duties enumerated in the Constitution. Now, what is a constitution? Is there a difference between constitution and constitutional law? What is constitutionalism? Is it the same as the constitution or constitutional law? Let us see. A constitution is a document which establishes the fundamental organs of the government and administration, describes the structure, composition, powers, and principal functions of government and administration, defines the relationship between these organs, and regulates the political relationship of these organs of government with the people. Constitutional law, on the other hand, is a broader term and includes the Constitution, the judicial decisions under the various provisions of the Constitution, and conventions like collective responsibility, privileges of Parliament, etc., which might not have been incorporated in the Constitution but are followed by the organs of governance. Constitutionalism is limited government or a limitation on a government. It is the reverse of arbitrary power and despotism. A country may be having a constitution but may not have constitutionalism. Example, a country with a dictator at the helm of affairs, whose word is law, may have a constitution but not constitutionalism. Constitutionalism visualizes checks and balances by restricting the power of the legislature and the executive and ensuring that they are not uncontrolled and arbitrary. Unlimited power may result in authoritarian and oppressive government, which endangers the freedoms of the people. To preserve the basic freedoms, the Constitution has to be infused with constitutionalism. Inbuilt restrictions on the powers conferred on governmental organs has to be contained in the Constitution. When the Constitution, instead of concentrating power at one point, provides for decentralization and also contains limitations thereon, only then the country is said to have both a constitution and constitutionalism. A written constitution, independent judiciary with power of judicial review, the doctrine of rule of law and separation of powers, free elections to legislatures, accountable and transparent democratic government, fundamental rights of the people, federalism, and decentralization are some of the principles and norms which promote constitutionalism in a country. Coming to the Indian Constitution, while drafting the constitution makers took cognizance of various constitutions working in different countries of the world and drew experience and wisdom in the area of governmental processes and evolved a constitution which suited the political, social, and economic conditions in India. Indian federalism is influenced by the American, Canadian, and Australian federations. Chapter on fundamental rights was inspired by the American Bill of Rights, and amendment provisions are a modified version of American system. Parliamentary form of government, system of prerogative writs, and judicial control over administrative action are inspired by the British model of governance. Australia's experiences were useful for evolving provisions pertaining to center-state relationship and freedom of trade and commerce. The Irish Constitution influenced the shaping of the directive principles of state policy. The Constitution of India is the lengthiest constitution in the world. It is a unique blend of rigidity and flexibility. It declares India to be a sovereign, socialist, secular, democratic republic. It prescribes parliamentary form of government. It incorporates a formal declaration of fundamental rights and fundamental duties and includes directive principles of state policy which set out principles of governance. Our constitution is federal with certain unitary features. It provides for adult suffrage and an independent judiciary. As already stated, the Indian Constitution is lengthy, elaborate, and a detailed document with more than 400 articles and 12 schedules. Why is it so? The reasons which contributed to this are: our Constitution deals with the organization and structure of the central government as well as the state governments. There are detailed norms on center state relationship, which is a matter of crucial importance in a federal constitution. Many unwritten conventions like collective responsibility of ministers, parliamentary procedure, etc., have been reduced to writing. Detailed provisions on fundamental rights, safeguards to minorities, scheduled castes, scheduled tribes, and backward classes are included in order to remove mutual distrust among various communities and groups in India. To ensure that the future India be based on the concept of social welfare, the Constitution includes directive principles of state policy. The Constitution not only includes the fundamental principles of governance, but also many administrative details such as the provisions regarding citizenship, official language, government services, electoral machinery, etc., in order to ensure smooth and efficient working of the Constitution. India is declared as a sovereign, socialist, secular, democratic republic. Socialist and secular have been added by the 42nd Amendment Act 1976. India is sovereign because it is not dependent on any outside authority, and the sovereignty rests with the people of India. Socialism emphasizes distributive justice in order to bring about the distribution of material resources of the community to subserve common good and attain social, economic, and political equality. India is a country of religions, but the Constitution stands for a secular state of India. This means that the state recognizes no religion as religion of the state and treats all religions equally. The word democratic denotes that the authority of the government is derived from the will of the people. The rulers are elected by the people and they are responsible to them. The word republic denotes that the head of the state, that is the President of India, is elected by the people for a specific period and is not a hereditary monarch. Justice, liberty, equality, and fraternity are declared in the preamble as the objectives of the Constitution. The Constitution establishes a parliamentary form of government, both at the center and in the states, which is responsible to the parliament at the center and the legislatures in the states. President is the executive head of the government, but the real executive power vests in the Council of Ministers, collectively responsible to the Lok Sabha. The members of the Lok Sabha are elected by the people directly by adult franchise for a term of 5 years. The position in the states is the same as in the center. There is another form of government called the presidential form of government, which is based on the principle of separation of powers. The president is elected directly by the people for a fixed term and is the real executive. The executive powers are vested in him and he is not responsible to the Congress. The members of the president's cabinet are not members of the legislature. They are appointed by the president and are accountable to him. Our constitution is a blend of rigidity and flexibility. While a rigid constitution cannot be amended easily and requires a special procedure to be followed for amending the provisions, in a flexible constitution, any provision can be amended easily by ordinary legislative process. Indian constitution is sufficiently flexible and only a few provisions require special procedure for their amendment. The Constitution incorporates fundamental rights which are restrictions imposed on the state, and the state cannot make laws which deny or curtail these rights guaranteed in Part 3. When the fundamental rights are violated, the Supreme Court is vested with the power to grant remedies in the nature of writs of habeas corpus, mandamus, certiorari, prohibition, and quo warranto. But these rights are not absolute and are subject to reasonable restrictions, and this is done with an intent to strike a balance between individual liberty and social interest. Part 4 of the Constitution contains certain directives. They specify the aims and objectives to be achieved by the state's governance. They are not justiciable, that is, the courts cannot be approached for relief for non implementation of these principles, but they'll have a bearing on the electoral prospects of the government in power. The aims and objectives contained in the preamble can be achieved only when the directive principles are strictly implemented by the state. Our constitution is a federal constitution with certain unitary features. Written constitution, rigidity, supremacy of the constitution, distribution of powers between the central and the state governments, and authority of courts to prevent the central and the state governments from usurping each other's powers and to have a final say in the interpretation of the constitution are the five distinctive features of a federal constitution, and they are present in our constitution. But certain features like absence of dual citizenship and lack of constituent authority to states to make their own constitutions are unitary features. The Constitution also adopted certain measures to mitigate the rigors of rigidity. It provides for a concurrent list which includes a number of subjects on which both the central and the state governments can legislate. The Parliament is empowered to legislate exclusively on certain state subjects under certain circumstances. The process of amendment of the Constitution is not as rigid as in the federal Constitution. In emergencies, the Constitution can become unitary. The Constitution maintains administrative and legislative unity by providing for a single judiciary, uniform fundamental laws, both civil and criminal, and a common all India services. State governments and the union government are required to work harmoniously in their own spheres without hindering each other, and the union government is vested with an overriding power only where it is necessary in the public interest. The Indian Constitution ensures that every man and woman above the age of 18 years is entitled to vote and elect representatives for the legislature without any qualification either of sex, property, taxation, education, or the like. An independent and impartial judiciary with the power of judicial review is provided under the Constitution to safeguard and enforce the fundamental rights vested in the individuals under Part 3 of the Constitution. The judiciary is not only a custodian of the rights of the citizens but also plays an important role in determining the limits of power of the center and the states. 10 fundamental duties have been introduced by the 42nd Amendment of the Constitution. They serve as a constant reminder to the citizens of India that while fundamental rights are specifically conferred on them by the Constitution, it also requires them to observe certain basic norms of democratic conduct and democratic behavior. These, in brief, are the salient features of the Indian Constitution. Thank you.